Assalamu alaikum and good afternoon, honourable judges, distinguished speakers, guests. Thank you so much for being here with us after lunch, which is often a slightly sleepier part of the day. So thank you for persevering and being here. My talk really will look at the challenges faced by the world of international arbitration today and the opportunities it presents for Pakistan and other emerging countries who are interested in embracing the practice of international arbitration. It will also then look at some of the challenges that are presented in seizing those opportunities by Pakistan. So I haven't done any domestic arbitration. My world has been international arbitration for the last 22 years, first as advocate and now more recently as arbitrator. And the three most prevalent challenges faced by the world of international arbitration today are delay, expense, and lack of diversity. And I speak about diversity not as the very sort of trending issue it's become, but really as an economic issue that is fueling the delay and expense in arbitration. Now, the object of international arbitration is set out very clearly in Principle 1A of the English Arbitration Act, and it's a very summarized view. The object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. Now, my world, the world of international arbitration, sadly has become very, very expensive, and the delays are massive. I am speaking from a very narrow set of statistics. There was a Bickel study which looked at 400 investment treaty cases, which are obviously public, and they found that it was taking an average of 4 years to conclude an international arbitration. And the costs were staggering. Tribunal costs were around $1 million, party fees together were around $10 to $12 million. Now, this is at the very top end of the game, but I fear numbers down the chain in international arbitration aren't too low either. And the reason, one of the reasons in my view, is the limited pool of international arbitration practitioners as well as arbitrators. It is no secret that international arbitration is dominated by arbitration hubs like London, Paris, Geneva, now Singapore, Hong Kong, and Dubai. And to some extent, that's a natural consequence of their trading situations, but equally, the efforts those legal systems have put to create themselves as arbitration-friendly centers. Now, the issue with diversity and how it fuels delay and expenses, that you really have a limited pool of arbitrators where parties are choosing from. The less than 30% of arbitral tribunals are comprised of women. That leaves out 50% of the population. The vast majority of arbitrators in international arbitration come from North America and Europe. Why is that? And the reason really is that the cornerstone of international or choosing an arbitrator is confidence. The parties must have confidence that the person has the competence and the ethics to make an impartial decision. And the other reason perhaps is more pedestrian. Most decisions are made by word of mouth. So if the arbitration practitioners are in London and Paris, their worldview is limited to their jurisdictions. They won't know what somebody in Nigeria or Indonesia is doing. What makes this lack of understanding even worse is the different standards. And this is where I get to the heart of the topic. By standards as an arbitrator, what do I mean? I don't just mean the competence, I also mean the ethical standards. It is no secret that different regulators have different standards. I'm regulated by the Bar Standards Code in the UK, which has a has a robust regulation regime. Other countries may not have the same standards for advocates. Arbitrators, interestingly, there is no official regulator for the arbitrators, and in this piece I do mention that CARB perhaps is the only unofficial regulator of arbitrators, where at least you have the ability to make a complaint against a member of the CARB, and there is a very detailed and an interesting process to follow. So when people talk about the fact that why, and this comes back to Pakistan, which has the potential to become a massive arbitration hub in terms of the talent it has, the fact that people speak English, the fact that arbitration is so transferable, at least process-wise. Why hasn't it become the hub it has the potential to be? And it comes back to confidence of the parties. And here I highlight the most important one. As they say, practice what you preach. In this case, practice what you advocate. Arbitrators are not born. They are forged through a system of education, training. They start right at the bottom, first as students, as Martin said, then they become advocates, then finally they become arbitrators. So the system has to encourage them at each level, and they have to be infused with the right set of standards, both educational as well as ethical. With Pakistan, the disciplinary mechanism perhaps is not as well known as it ought to be. Hence the confidence of the outside world in terms of the regulation of both advocates and arbitrators is difficult. And it's made all the more difficult given the nature of the Pakistani society, where everybody is connected. There are issues of influence, there are issues to even threats to life. So there is a reason why there is that perception issue, not just in terms of the competence, but also the ethical standards. And this is where I think having standards and a regulator will really help. Today, ask yourself, if you appoint an arbitrator and for some reason something goes wrong, who do you go to in Pakistan? Do you go to the Punjab Bar Council? Do you go to the court that appointed him? But what if it's not a court-appointed arbitrator? Then do you go to the courts to take some kind of legal action? That's a hugely cumbersome process. So the need for standards, both the hallmark of quality, is absolutely imperative in bringing Pakistan in alignment with the major arbitration hubs. And this is where perhaps the challenge lays. Pakistan is not seen as an arbitration hub, although the fact that so many have made such long journeys to get here today testifies its potential to be one. And as Mr. Lando said earlier today, the time will definitely come. The question is readiness. Here, I think, two recent developments, or as they call disruptions in the tech world, will help Pakistan tremendously. The first is the digitalization of the economy post-pandemic. And here I'm not talking about the thorny issues of virtual hearings. International arbitration is pretty much written submissions. We really have one hearing at the end of the process, which is in person, which is a week or so. And most arbitrators and arbitration practitioners can make their way to the hearing. The question is that of perception. Pre-pandemic, most people were very uncomfortable using services from people far away, and they didn't know how to connect. Now, given that we've lived in a virtual world for over 2 years, parties are certainly more open to talking to people outside their immediate geographical footprint. And here there will be the potential to provide services, not just as arbitrators, but as arbitration practitioners. And here I touch upon the challenges, as I mentioned earlier, delay and expense. Certainly, the gap in the market could be filled by arbitration advocates and arbitrator practitioners from Pakistan, which could improve the pool of potential arbitrators and indeed offer cheaper and better services. in terms of time and value for money. The other opportunity is the new trading relationships with China and Turkey, with new emerging countries with their own homegrown advocates which are keen to get into the world of arbitration and take their role rather than being heavily reliant on the London market or other traditional arbitration hubs. Now, the real challenge in embracing these two is quality control, hallmarks of quality, training, regulation, and disciplinary action. And this is where I believe that the CARB is a fantastic step in the right direction, because here at least you have a system or a membership where there is a hallmark of quality that hopefully parties will get, and also the promise of some sort of a regulatory sanction. So I hope very much that this is the start of many exciting things to come in arbitration in Pakistan, and thank you very much for taking the time to be here.